Welcome to the Virtual Center for the Study of the Constitution and Civic Responsibility, an ongoing inquiry into American political origins and evolving institutions. The Executive Director of the Virtual Center is Dr. Bill Obrien. He's also your host for this continuing conversation. Here he is now, Dr. Bill Obrien.
Well, thank you, Bob Kincaid. And there's 2 days this week that I had the pleasure of chatting with you. Welcome to this Wednesday edition of the Virtual Center for Study of the Constitution and Civic Responsibility. Today, of course, is Halloween. It is the 31st day of October in the year 2018. It is a pleasure to be with you today. I apologize for not doing a live program yesterday. I'm feeling a little bit under the weather. I think I had a little virus or something. I've, had all the earmarks of it: chills and headache and stomach upset and the runs and all of it, I guess. So I just, I had it the night before and I was up half the night. And when I did finally go to sleep, I didn't wake up until almost 11 o'clock yesterday morning. So I really, didn't quite feel up to a program, but everything's fine. I feel fine. I hope that it was only one of those short things, and it was, and I feel much better today. So again, I do apologize for missing the program yesterday. There's just no shortage of stuff. I was thinking about the program today, and I obviously the key issue is the president's announced intention to try to change the Constitution of the United States by executive order. That it seemed to me was the key factor, but I thought to myself, well, I can't, that's not an issue that would take up 2 hours, unless we get into a discussion about it, which I'd love to have. But there are so many other things. And one thing happened in my class this morning that I thought I would share with you. And it seemed to be significant as well. So I've got a number of things. There's just so many things going on at the same time. And of course, we realize with the election coming next Tuesday, there's a lot going on in that sphere as well. I think many of you probably, as I did, watched the 1 hour Chris Matthews program last evening with Beto O'Rourke. I hadn't, other than clips, I hadn't really seen him for any extended period of time and listened to him. So I was anxious to tune in on that and catch that, and I found it pretty encouraging. But anyway, that's neither here nor there. And but first, before we begin anything, let me give you our phone numbers and invite you to participate in our program. As I say, this effort of the president to take on the 14th Amendment by executive order is really significant, and I think a lot of people are focusing on it as being significant, if for no other reason than the makeup of the Supreme Court. The assumption is that eventually it'll end up there, and the hope is, and I know a couple of the pieces that I read on this particular thing this morning leaned in this direction. The thinking is that the inability of the president to do this is so clear that even this Supreme Court would not really have an option, much of a choice. But again, I think we get into it, it's a little bit more involved than that. So, but first, let me share with you the information so you can communicate, if you choose to, with our other listeners as well, and perhaps get a conversation or a discussion started on this. We have two phone numbers, each of which will take you directly into the Head On Radio Network studios, and Bob's there, and he'll get you on the air immediately if you call in. The first number, it's the one we've had for some time, is area code 304-574-8178. That's 304-574-8178. The newer number, which will accomplish the same thing, get you directly into the studios, same area code, 304-640-2829. 304-640-2829. If there's something you'd like to say and trust that I can get it on the air for you, I'd be glad to do that. You can communicate directly with me either in an email or by using our Facebook page. My email address is waobrien906@gmail.com. That's waobrien, O-B-R-I-E-N, 906@gmail.com. And that's all one word, no spaces, lowercase. If you'd like to use our Facebook page and communicate directly with me that way, you can do it by going to our Facebook page, and you do that by typing the Virtual Center for Study of the Constitution into the search box at the top of the homepage of Facebook. And that'll get you to our Facebook page, and you'll see a number of postings there. And after each posting, there are two boxes. One is a comment box. The other one is a share box. If you click on the share box, then that particular posting will automatically be distributed, sent to your friends on your Facebook page. And that would obviously give us a little bit more visibility. And we would obviously appreciate that. But if you click on the comment box, then you have an opportunity to make a direct comment to me. Presumably, the comment would be about the particular posting, but it doesn't necessarily have to be that way. You can comment on anything that we've been dealing with the program. If you'd like to make a comment, for example, about President Trump's effort to change the 14th Amendment in the area of citizenship, then, by all means, you can do it that way. But again, I think it would be much more effective and timely if you would like to make comment about that one way or the other by calling in. I think everybody who is listening in would appreciate it. And again, it's a way for all of us to learn. The issue, of course, and I'm sharing this with you briefly. Let me point out that there are a number of pieces in today's media about this particular issue. I think it's interesting that in the Washington Post there's an article co-authored by an attorney who happens to be the husband of Kellyanne Conway. But he's a very, very strong, has been regularly a very strong opponent of the Trump administration and the president's programs. So, that's been kind of an item that comes up periodically in the media. But in this article in the Washington Post, the point was made that this is blatantly unconstitutional as well. And the two people that wrote it are both attorneys for significant law firms in and around D.C. The article that I happen to have in my hand, which is another one, and I copied this one because of the person who wrote it, namely American historian Eric Foner. Eric Foner is one of the more prominent American historians we have, and his specialization is on the so-called Reconstruction period after the Civil War. He's written a lot of books about the origins of the war itself, and especially the Reconstruction period afterwards. And of course, the 14th Amendment was drafted and ratified a couple of years after the end of the Civil War. So, Eric Foner is, at least from everything that I've been able to gather, one of the nation's foremost experts on this particular period. And of course, what we're talking about here is the president's interview on Axios, in which he said that he was going to, that he intended to issue an executive order ending what he called birthright citizenship. And birthright citizenship, of course, is the idea that a child born in the United States, whether in fact the parents are citizens or not, whether in fact they're even here and are not citizens, the child becomes a citizen merely by being born here. And the president, even during his campaign in 2016, focused on this and said it was something that he wanted to change. However, he said in this interview, it was always told to me that you needed a constitutional amendment to do it. But guess what? He said, you don't. So his advisors have basically indicated to him that he can make this change merely by executive order. And of course, that becomes significant in thinking about the issue itself with President Trump, because President Trump was one of the most outspoken opponents of President Obama's use of executive orders, which increasingly Donald Trump labeled as unconstitutional, that President Obama was making changes by executive order that in many cases were unconstitutional. So it's kind of ironic now that the president seeks to use that same avenue that Barack Obama used. Eric Foner points out, of course, and this I think is significant, that by doing this, just by trying to do this, even though he believes, I believe, that it's unconstitutional, Foner points out that it would violate something very, very critical to the entire American idea. And that is that anybody, irrespective of race, religion, national origin, or legal status of one's parents, can be a loyal citizen of the country. And Foner points out that the so-called birthright citizenship was first enacted into law by the legislature, by Congress, in the 1866 Civil Rights Act. And the ratifying of the 14th Amendment happened 2 years after that, in 1868. And historically, and I think I've made mention of this before, but the reason it's in the 14th Amendment was because prominent people at the time didn't believe that having it in a piece of legislation in the Civil Rights Act was permanent enough. It could be easily overturned by a later Congress. But they believed that by installing it or embedding it in the Constitution of the United States, it would be permanent and nobody would be able to change it. And here we are. We finally reached a president who believes that indeed he has the authority unilaterally to change it. In the 14th Amendment, there are a couple of exceptions to birthright citizenship. One is persons not subject to the jurisdiction of the United States. And according to Foner, at the time, that meant Native Americans who lived on reservations. And of course, prior to the Civil War, it would have included slaves as well. It's kind of, I mentioned this a couple of weeks ago in the class I'm teaching, and I think I may have actually covered it here as well. But the Virginia Declaration of Rights of June 1776, which was less than a month before the Declaration of Independence was written, the Virginia Declaration of Rights includes in its first article a phrase inserted by Edmund Pendleton of Virginia, in which he included this particular phrase, subject to the jurisdiction of the United States, because that was his way, without mentioning the word slave, that was his way of excluding slaves. And so that phrase, that particular phrase, has been has been used before. But it does appear in the 14th Amendment, and it means that excluded from this birthright citizenship, if you will, would be Native Americans. And the other one would be the children of foreign diplomats. You know, if a diplomat from another country was serving in the United States and they gave birth to a child, that child would not automatically become a citizen of this country either. But except for those two exceptions, it applied in theory to everybody else. But in fact, it didn't. Because even though it included ex-slaves, African Americans, it did not include Asians in reality until the end of the century in 1898. And it's interesting that a Supreme Court decision in 1898 extended birthright citizenship to the children of Asians born in this country, but it did not extend to their parents. In other words, citizenships for Asian Americans didn't come until the early 20th century. So, you know, it's important to recognize that even though with the inclusion of ex-slaves, this idea of birthright citizenship seemed to be universally extended. In fact, it really was not. At the time, in the 19th century, at the time that the 14th Amendment was drafted, Congress requested a lawyer at the time to investigate whether in fact there was some sort of a legal definition of a citizen, of citizenship. And the attorney they went to was named Horace Binney, and he reported that the word citizen occurs 10 different times in the Constitution of the United States, but never is there any definition of citizenship given. So in reality then, this particular statement of the 14th Amendment, the first part of the 14th Amendment, defines citizenship in a way which is consistent with what Lincoln called the creed of the United States, which is the self-evident truths paragraph of the Declaration of Independence. And of course, one of the reasons for doing this was not only done because of the freeing of slaves, but a few years before the Civil War broke out, in 1857, the Supreme Court had decided Dred Scott. And in the Dred Scott decision, the court specifically excluded slaves from any consideration of citizenship. In fact, the Dred Scott decision declared that no black person, slave or free, could be a citizen of the United States, and I find this interesting, or part of the national political community, unquote. So the implication of Dred Scott was that the Supreme Court was on record as denying citizenship now or in the future to any black American, slave or free. And of course, there were tens of thousands of free blacks in America even before the Civil War. So basically, Foner points out that the 14th Amendment was meant to provide for the first time a uniform national definition of citizenship, one in which states could no longer be able to deny that that definition or deny citizenship to Black Americans. And basically, to Foner, and I want to read this because I think it's really significant. It included all persons, including aliens, the equal protection of the law as part of an effort to create a new egalitarian republic on the ashes of slavery. In other words, we were going on record, as stated in the 14th Amendment, as declaring what citizenship in this country meant. And what it meant was equality, irrespective of race, religion, nationality, all of it. There's one issue in the fourth, and I'm just going to mention this, but I think it's significant. There's one issue in the 14th Amendment that I do believe is significant. It includes a phrase, all citizens subject, all persons subject to the jurisdiction of the United States. When I saw that, when I heard about the president and his intentions, and then looked again at the 14th Amendment, at the wording of the 14th Amendment, that phrase jumped out at me. Because one might argue that children born of illegal aliens, because they are illegal aliens, are not subject to the jurisdiction of the United States. That phrase seemed to me to open the possibility of an argument that maybe, in fact, Trump might have something here. And I hadn't known this until I was chatting with Bob before we went on the air, but Bob pointed out that the Heritage Foundation has already written and taken a position supporting the president's right to do this based on that phrase. That question came up in the discussions that I've been, and the issues that I've been reading. And the fact of the matter is, if one is in the United States physically, then one is subject to the jurisdiction of the United States. The mere fact that you're here illegally, and therefore you're kind of living in hiding, so to speak, you are still subject to the jurisdiction of the United States in terms of violating the laws and various other things. You're subject to arrest, you're subject to all of these things. So it seemed to me, when I looked at it, that particular phrase, you were really stretching to the nth degree to make the case that the children of illegal aliens could be denied birthright citizenship because, technically speaking, since their parents were here illegally, they were not subject to the jurisdiction of the United States. But in practical reality, that's not true. They are. So I really think, and Bob's point, and I don't want to go too far into this because, very honestly, I'm not sure that I could go nearly as far into it as Bob plans to, because of the background, the legal background that he has. But the children of Orientals, of Asians, were extended birthright citizenship in a case decided by the Supreme Court in 1898. referred to, and I can't remember the exact name of the case, but most people refer to it as the Kim case. But the fact of the matter is citizenship didn't extend to their parents, even though it was extended to their children. And Bob's emphasis is on the year 1898 of that decision. And his point is that it's very clear that the 1898 Supreme Court is the same Supreme Court that rendered the Plessy versus Ferguson decision separate but equal. In other words, that particular court was emphasizing race and was clearly racist. So the fact of the matter is, even though birthright citizenship was extended to Asian children born in the United States and not their parents, indicates the racist intentions and the racist assumptions of this particular court. And of course, the fact of the matter is, if you look at the president, one could look at an effort to alter the 14th Amendment by changing or denying children born here of illegal aliens birthright citizenship as being an example or a manifestation of racism as well. And of course, given all the other things that we've seen from this administration, that's not much of a stretch to make that case. There's an awful lot involved here, it seems to me, and it's extremely important. Also, there are political ramifications to this. There's a political context to this. It's very clear if you read, and you don't have to read any particular article because it's in several, but there are numerous reports available of the extent to which the president is extremely frustrated by the violence that has occurred with the mailing of the pipe bombs last week, and then the slaughter of the murder of 11 Jews in the synagogue in Pittsburgh on Saturday morning. The result is that the media has been focused principally on these outbreaks of anti-Semitism, racism, and threats of domestic violence and reality of domestic violence. And the reports are that the president is extremely frustrated by this because it's taken him off the front page. The media while this has been going on, the president's political efforts to affect next Tuesday's elections have been put on the back burner as far as the media is concerned. Most of the media attention is still on Pittsburgh, on the funerals that are happening, on the president's uninvited trip to Pittsburgh yesterday. There's no question. In fact, I read one article this morning in which this was in the title of the article. The president is coming up with one tactic after another. He's throwing one thing after the other against the wall to see which one might stick. And that in that context, this intention to end birthright citizenship by executive order is merely one more effort by the president to take back control of the headlines. So it's a political strategy in a sense. And there's some thinking that he may not really intend to go through this at all, but it's getting the kind of attention that is putting the focus back on him and away from the victims of Pittsburgh or to the intended victims, potential victims of the mailing of the pipe bombs. There's no question that if you look back at what the president's political emphases were before last week, before these issues related to violence happened, the president was emphasizing, for the most part, the caravan, the threats, the so-called caravan invasion of the southern border of the United States, and his decision to put 5,200, over 5,000 members of the military on the southern border to keep these people from gaining entry to the country, whether in fact they're here claiming a request for asylum or not. And that basically that was his effort, that was his outreach, that the president's emphasis politically with the oncoming of the election was intended to be on immigration, was intended to be on the threat of this caravan invasion. And since he's been knocked off the front page of the newspapers by these outbreaks of violence, or prospective violence, the president has been desperate to try to get the focus back on him. And he apparently, from what the reports say, is very frustrated by what's happened, because the media is beginning to report that in the last week, the Democratic outlook for next Tuesday's election has improved significantly in the last 4 or 5 days. And I'm a little bit reluctant to pay much attention to the polls, because let's face it, the polls never really picked up on President Trump having much of a chance to win the election in 2016. And a lot of people are always suspicious of polls anyway, because people don't respond honestly, obviously. It's very obvious that many of the people that voted for President Trump never admitted that they intended to vote for President Trump. But the fact of the matter is the polling indicates that in the last 4 or 5 days, a clear Democratic surge has emerged. And this bothers, obviously, the president a lot. He's extremely frustrated by this. Margaret Hagerman and a couple of other writers in this morning's New York Times, for example, talked about the role that Ivanka and Jared Kushner played in persuading the president to go to Pittsburgh. They kept pushing him and telling him he had to go. He had to go. And even though he wasn't invited, and even though large numbers of people told him to go home, and that there were protests in Pittsburgh against his visit, the mayor requested that he not come until after the funeral services were over. And the idea being that the emphasis had to be on the grieving and the families that were grieving. That had to be the focus, not the president's visit. At least that's what the mayor said. And apparently, Ivanka and Jared Kushner were insistent on the president going in large part because he was so frustrated as to what was happening with the election, that the tide seemed to be turning and he couldn't do anything about it. And a lot of people put this effort to issue an executive order to eliminate birthright citizenship, a lot of people put it into that political context. In other words, it's really not clear whether in fact he intends to do this or not. But by saying it, he's trying to shock public opinion to the point that it'll begin to focus more on him in the last 4 or 5 days before the election and away from Pittsburgh. It's obviously hard to know. It's impossible to know. But we do know that this president is a fan, has frequently shown an indication, a desire to shift the focus, shift attention, do things in order to shift the focus of attention of public opinion away from areas that he doesn't want public opinion focused on. So I do believe that this birthright citizenship has to be considered, at least in part, in its political ramifications, its political context. I mentioned at the beginning of the hour, we got about 20 minutes left, so I think we might be able to do this. I mentioned this morning that something had happened in my class this morning. It didn't happen. It wasn't an event necessarily. But I thought to myself after the class was over that this really was significant, and it was a significant change for me, at least, in terms of teaching the particular subject that I was dealing with this morning. I've taught it numerous times. I've covered it numerous times because I've taught this class, in the last half century. I've probably taught this class 40 times. What I'm talking about is the period immediately following the War of 1812. It's a period that doesn't get a lot of attention, but I think it's a very significant one. It's marked by an outburst of nationalism in America. And it's that nationalism that I wanted to spend some time on this morning. And it happens in a number of different areas. In other words, there's economic nationalism happening at the end of the War of 1812. The Supreme Court, under the tutelage of Chief Justice John Marshall, engages in some major court decisions during this period, which speak to the issue of nationalism. In 1822, President Monroe, at the urging of his Secretary of State, John Quincy Adams, issues the very famous Monroe Doctrine of 1822, which is a blatant statement of American nationalism to the world, by basically announcing to the world that colonization in the Western Hemisphere is no more. Many of the former colonies in Central and South America that had been colonies of Spain had successfully won their independence in the early 19th century. And at the end of the war, which ended in 1815 with the Treaty of Ghent, with the ending of the war between England and France, and simultaneously, or because of that ending, the ending of the War of 1812 as well, the nation undertook a burst of nationalism. And as far as the economy is concerned, and this is what I wanted to deal with nationalism. Never before in teaching this class did I feel the need to do that. I always felt that the only thing that you had to do with nationalism is define it or explain it. And basically talk about the more prominent role of the federal government in the areas of the economy, in the areas of interpreting the Constitution, in foreign policy, and all the rest of it. And that's as far as I've ever felt that I needed to go. But that's all changed now. as a result of the current Trump administration. It changed a couple of weeks ago during one of his rallies when the president made a point of emphasizing that he was a nationalist. And to many people, that raised flags. Because historically, the word nationalist has a very negative connotation. For example, the Nazi Party was a nationalist party. Mussolini's fascism was in effect nationalism. The white supremacists marching in Charlottesville last year, screaming anti-Semitic statements about Jews. These white supremacists are frequently referred to as white nationalists. The whole idea of nationalism has assumed negative connotations. It's become a loaded word. So I felt that I needed to deal with it. And I felt that as I went through the content of this period, with examples of economic, judicial, and diplomatic nationalism, that it was really important to recognize that if nationalism has a negative connotation, it's in large part because of our politics that it does so. That traditionally this was not anything that you paid particular attention to in covering this period. And so what I was doing was pointing out, for example, this was the period in Congress, which is really interesting, when President Madison, who had led the opposition to the chartering of a United States bank in the first Congress in response to the efforts of Alexander Hamilton to promote a U.S. bank to the first Congress and getting it through. The U.S. bank was chartered for 20 years, which meant that its charter expired in 1811. The very next year, the United States ended up in another war with Great Britain, the War of 1812. And militarily and financially, this war was a disaster. And part of the reason it was a disaster economically was because there was no United States bank. There was no, from the national level, from the top, there was no management, if you will, of the economy, of the currency. Rather, the only banks that were in operation were state banks. And the economy took a tremendous beating during the War of 1812. In large part because the bank was not in existence. When the war ends, Madison goes before Congress and proposes the chartering of a second United States bank. The very people that opposed the bank as unconstitutional are now advocating for it because they've seen what the nation has experienced without it. So Madison and the Republicans are proposing a United States bank. They're also proposing something else that they opposed in Hamilton's program, which was tariff protection for new American industries. As a result of the embargoes enacted late in the Jefferson administration and continued during Madison's administration. And the whole idea, if you think about it, the word embargo implies a total shutdown of commerce. There's nothing being imported from overseas and nothing being shipped overseas, nothing being exported. The result is the United States enters a serious recession as a result of its embargo policies. What our textbooks refer to as peaceable coercion. That's what Jefferson referred to it as. peaceable coercion. In other words, the idea, the assumption that the rest of the world was so dependent on American agriculture that it gave us international leverage. And by shutting down our ports and halting trade with the rest of the world, Madison and Jefferson both believed that other countries would come begging for us to resume trade because they were so dependent on American agriculture. Fact of the matter is that did not happen. But those who benefited from the war were infant American industries, new American businesses just getting started, who were having trouble competing with foreign imports. Because obviously the British were not at all opposed to cutting their prices in order to undersell American manufactured goods, which would essentially drive these new industries out of business. Madison realized then at the end of the war, when Britain began to dump manufactured goods on the American market once trade was resumed and once the war was over, that the government had to do something to protect these industries, or foreign imports would knock them out of business. So in 1816, Madison proposes, and Congress adopts the nation's first protective tariff, a high tax on imported goods, in order to make buying American goods more attractive because the prices were lower. Madison had opposed Hamilton's program because he believed that it benefited Northern industry and Northern manufacturing, Northern business. Now he's promoting legislation designed to prop up and support those businesses. So when you look at all of this, and then the third thing is Henry Clay's idea of internal improvements, that in order to expedite the internal trade and commerce transportation system within the country, the government had to become directly involved in what we call today infrastructure. The building of roads, the improvement of existing roads, the construction of canals and ultimately railroads. Government, Clay argued, had a significant role to play in these. And so Clay's position in the House of Representatives put him in a position to steer much of this nationalistic legislation through Congress. So when you look at all of these, the idea of government subsidizing internal improvements in order to promote economic growth, economic expansion, is a totally new role for the federal government. The government had never tried to undertake anything quite this ambitious before, except under Hamilton. And one of the things that happened under Hamilton is that the proposal for a protective tariff to protect American industries never happened. They could never get that through Congress. But it went through Congress at the end of the War of 1812. So what we see during this period is a marriage, a political marriage, if you will, between government and economic development, where government is playing an active, visible, aggressive role in promoting those aspects of the economy designed to promote economic expansion and economic growth, which is exactly what Alexander Hamilton had argued before almost a quarter of a century earlier. In order to do all of these things and get the American people to accept them, the way the court interpreted the Constitution was critical. And so these decisions by the Supreme Court under John Marshall become critical. There are numerous important decisions reached during this period by the Marshall Court. We only dealt in class this morning with a couple of them, some of the big ones. There were three. I'll make reference to them in a moment. But the point is there were a number of others. Decisions like Cohen's versus Virginia and various other cases where Marshall is articulating and defining for the nation a proper role and an important role for government in the nation's overall growth and development. In other words, Marshall is securing within the Constitution the kind of powers that the federal government would need in order to promote economic expansion, growth, economic growth. And he does it in these Supreme Court decisions. In this period, there are three that I chose to mention. The first one is the case of Fletcher versus Peck, which is a decision the court rendered in 1810. It was a case that was set in Georgia. It was a land case. It was a case of land speculators who was literally stealing land from Native Americans in the West, in western Georgia, by conning them into signing, fraudulent contracts, sales contracts. When a new legislature came into power in Georgia, it set out to rescind all of these land deals by the previous legislature, pointing out that they were rotten with fraud. And the land companies which had purchased these lands went to court against the state. And the case became Fletcher versus Peck. And in that case, for the first time, Marshall focused on the contract clause of the Constitution, which is in Article 1, Section 10. Let me share that with you. Article 1, Section 10 of the Constitution deals with the various powers, enumerated powers, that Congress is given under the Constitution. But this particular item, this particular section, includes the statement of powers denied to the states. And the point I was making to the group this morning was that if you look at the specific powers that the Constitution denies to the state, clearly denies, specifically denies, they are the very powers that Madison and other nationalists believe were the problem under the Articles of Confederation, because the Articles of Confederation specifically gave these powers to the states and denied them to the central government. So the Constitution totally reverses that. And here's the clause in question. No state shall enter into any treaty, alliance, or confederation, grant letters of marque and reprisal, coin money, emit bills of credit, make anything but gold and silver coin a legal tender, a tender in payment of debts, pass any bill of attainder, ex post facto law, or law impairing the obligation of contracts, or grant any title of nobility. In other words, there are a number of very specific limitations on what the states can do in the Constitution of the United States. And the one that Marshall is focusing on here is the one which forbids states for passing any law impairing the obligation of contracts. Marshall makes the point in Fletcher versus Peck that even though there was fraud associated with these land grant deals, the fact of the matter is they were contracts. And Madison argued that no state government has the power to violate the obligation of contracts, even though they were fraudulent. So what Marshall is doing is coming down on the contract clause as a way to justify the enhancement of federal power. But he's doing something else. And it's the something else that I never felt needed to be emphasized before when I taught this. But it does now. And that's the relationship between contracts and corporations, business. By the solidifying of the contract clause, the emphasizing of the contract clause, Marshall is making it clear that the priorities of government, that the priorities of business, the priorities of corporate America must become the priorities of the government of the United States. The marriage between government and business, which is what drives our economy, is being established and rationalized in the Constitution of the United States by Chief Justice John Marshall. There's something else to think about here, and I thought it was important to mention this morning as well. We know, because of all the conversation surrounding the nomination of Brett Kavanaugh a few weeks ago to the Supreme Court, we know how heated the contests for positions on the court have become, how political the issues related to the appointment of justices has become. We also know that the issue of judicial precedent is critically important, probably never realizing before just how much. Many of us remember that Susan Collins, in casting her vote for Judge Kavanaugh, consistently made the point that Kavanaugh had assured her privately, in person, that he would take seriously judicial precedent, that he would not become so political as a justice that he would trample on the precedents of previous courts. But it's important to realize when Marshall was rendering these decisions, there were no judicial precedents other than British common law for the most part. The court had been relatively inactive in the first few years of the nation's history. That's the reason that so many justices had voluntarily withdrawn, resigned from the court, John Jay being one. So in effect, what Marshall is doing in these decisions is establishing precedent. He's not relying on precedent because there's really not any there yet. So when he comes down heavy on the contract clause as a justification for business supporting for government supporting the priorities of business of corporate America, he is in effect establishing a precedent that future courts will have to consider seriously in rendering decisions for cases that will come up later. Marshall reinforces his emphasis on the contract clause in the very famous case in 1819 of Dartmouth College versus Woodward. This has always been one of my favorite cases. Maybe because I was always moved by the fact that the attorney for Dartmouth College in arguing the case before the Supreme Court was Daniel Webster, who was a Dartmouth graduate. And the reports are that Daniel Webster's impassioned plea on behalf of his alma mater was so emotional that he actually wept in making his presentation. That he, in fact, cried before the Supreme Court because he was so passionate about what he was arguing, because it was his college, he felt. Marshall's decision in Dartmouth College focuses once again on the contract clause. Basically, Dartmouth College was founded in 1769, before the Declaration of Independence, when New Hampshire was still a colony. In other words, when the 13 colonies were in existence. At that time, New Hampshire had just become had become a colony earlier on, and the king granted the charter to Dartmouth College in 1769. Marshall's argument in the Dartmouth College case was that even though this charter, this contract, was entered into before American independence, it was a contract nonetheless, and it needed to be honored. So in the early 19th century, when Jeffersonian Republicans took control of many of the state governments, it's understandable politically that one of the things that Republicans would try to do would be to unseat Federalist enclaves in the state. The New Hampshire legislature focused its eye on Dartmouth College, which was a private college under charter granted by the King of England. And they decided that as part of the Jeffersonian Revolution, these representatives of the citizens of New Hampshire felt justified in passing a law making Dartmouth a public institution subject to the legislature's governance. And of course, the trustees of Dartmouth College sued, hired Daniel Webster, and ended up before John Marshall in the Supreme Court in this case. And in the decision, Marshall focused on the extent to which the King's Charter was in reality a contract. And the Constitution of the United States, Article 1, Section 10, made it illegal, unconstitutional, for any state to pass a law abrogating the sanctity of contracts. And that's the story of Dartmouth College versus Woodward, I always thought. But the fact of the matter is, if you read Marshall's decision in Dartmouth College, if you printed it out, it would print out to probably 45 or 50 pages. It is a huge legal statement. And not that much of it focuses on the decision related to the degree to which Dartmouth's charter was a contract. The decision is easy. Clearly, it didn't need 50 pages of opinion to justify it. When you read Marshall's opinion, in Dartmouth College, in the Dartmouth College case, it becomes very clear that John Marshall is using the Dartmouth College case as an opportunity to grant personhood rights to corporations. Not only does Marshall point out that the charter is a contract, and therefore no state can constitutionally violate that contract, but Marshall also goes to great lengths to point out that Dartmouth College is a corporation, a private corporation. And the bulk of this opinion focuses on that, focuses on the extent to which corporations are entitled to the rights of personhood. That precedent that he establishes in Dartmouth College and reinforces the same year in the McCulloch versus Maryland case, which justifies the constitutionality of the bank, of the U.S. bank, it also is a corporation. It's a public corporation, but it's a corporation. It's the U.S. bank, not a state bank, not a private bank. What Marshall is doing is establishing the right of the federal government to incorporate business. Up to this point in time, state laws, state constitutions granted the right of incorporation. And we know that what incorporation does is limit liability. If you know anybody that has gone into business for themselves, I've gone way beyond the top of the hour and I apologize, but this is important, so let me try to finish it. States realize the need for corporations. And so what incorporation laws do is limit liability. If you know anyone who's gone into business for themselves, the first piece of advice they're going to get from those who know is to make sure you incorporate. Because when you do that, when you become a legal corporation, you limit your losses should you be sued for anything to the value of the business itself. In other words, nobody can sue you for something that the business did and take your home and your car and your bank account, your retirement account, and everything else. In other words, you could be wiped out. And of course, states realized that businesses that were so subject to damage in the courtroom, people would be much less inclined to go into business, to risk a business, for fear that if anything happened, they could be wiped out. States realize the way to avoid this is to give corporations special protections, limit their liability, so that if you are sued, you can only be sued up to what you've got in the business. What you have personally is not subject to this kind of a suit. What Marshall is doing is establishing the right of the federal government to incorporate or to support corporations as well. And he uses the Dartmouth College case as an opportunity to go into detailed analysis of what a corporation is, why it must be considered a legal person, and what that granting of personhood does for the corporation in terms of encouraging businesses to form corporations and to go into business and stay there. And what I did this morning was copy for students a couple of paragraphs from Marshall's decision in Dartmouth College. When I taught this material before, I never got into this. I didn't even know. The textbooks don't tell us anything about the focus on corporations in Dartmouth College. What our textbook tells us is the focus on the contract and on the issue of the contract clause. But the fact of the matter is, if you read Marshall's opinion, it's very clear that Dartmouth College decision is really not the most important part of the case. The opinion is for what it says about business. Marshall says, and I'll just read a couple of lines of this and you'll get the idea. A corporation is an artificial being, invisible, intangible, and existing only in contemplation of law. Being the mere creature of law, it possesses only those properties which the charter of its creation confers upon it, either expressly or as incidental to its very existence. And then Marshall goes into a detailed analysis of why governments charter corporations in the first place. These are such as are supposed best calculated to affect the object for which it was created. Among the most important are immortality and, if the expression may be allowed, individuality, properties by which a perpetual succession of many persons are considered as the same and may act as a single individual. And he says later on in the same paragraph, but this being does not share in the civil government of the country unless that be the purpose for which it was created. Its immortality no more confers on it political power or a political character than immortality would confer such power or character on a natural person. It is no more a state instrument than a natural person exercising the same powers would be. In other words, what Marshall is doing here is laying out the ingredients of what a corporation is about and why it's created in the first place. The reason government endorses the chartering of a corporation is because the corporation is committing to provide some sort of a public good that government itself can't or has not yet sought to deliver for itself. In this case, these trustees have put up their own money to found a college in New Hampshire whose stated purpose is to educate Native Americans. To the King of England, that was a worthy thing to do. It's not something that the British government felt it ought to be doing, but it's something that needed to be done, the king must have believed. So therefore, he gave these trustees the charter they needed to do it. Marshall explains that. And Marshall explains as well that once you create a private corporation, you can't interfere with it in any way as long as it's performing the objective for which it was created. In other words, as long as the corporation continues to fulfill the obligations it made when it was incorporated in the first place, then government can't touch it. But Marshall makes the point that while it is a person legally before the law, it does not have the same political rights as natural persons do. And that's the issue that is currently being challenged right now by our current Supreme Court majority, conservative majority. If you remember the final decisions of the last session of the court, the very last decision, you remember, was the one written by Justice Kennedy. It's the last decision before he retired, and now we know was replaced by his former clerk, Brett Kavanaugh. It became very clear in the Jansen case, which was a labor case, and we covered this a few months ago here on the Virtual Center, which denied unions the right to collect dues, to collect fees, so-called agency fees, from non-union members. And it's pretty much seen as a death blow to union strength and influence in this country. I think I said that Kennedy wrote that decision. I kind of believe it was Alito, now that I think about it. But what's coming out of this, what came out of that decision, was Justice Kagan's dissent and her warning that this conservative majority on the Supreme Court was looking at the First Amendment and finding ways to grant First Amendment rights to corporations, the same right as natural persons had. In the Dartmouth College decision, John Marshall establishes and explains why corporations have to have certain rights as artificial persons. But he also makes clear that these rights don't extend to political rights. But now that is being apparently challenged by today's court. And Justice Kagan predicts trouble. That much of the social legislation in the country on the books that protects people from employers, protects the security of their jobs, will be endangered as the court finds more and more ways to grant more and more rights to corporations. And as we know, this issue of corporate personhood came to a fore 8 years ago in 2010 in the case of Citizens United versus the Federal Election Commission. So these Marshall decisions, these precedents, are becoming critical. I think it's important, and this is the new wrinkle for me in teaching this material after the War of 1812. And that is that when you're talking about nationalism, court cases, you're talking a lot more about a lot about strengthening the federal government, the right of the federal government to play roles in the economy, and to do things internationally that government in this country hadn't tried to do before, because the central government was explicitly forbidden from doing anything under the Articles of Confederation, except take its marching orders from the states. So in establishing these precedents for future court decision, Marshall is establishing a major principle associated with nationalism. And that is that government from the very beginning must support the priorities of business. It's almost a throwback to the 16th and 17th century issues associated with the term mercantilism, where government is writing charters to companies to found colonies. Government is supporting the priority of the investor groups, of the banking groups, the financial groups, knowing full well that these were the people who were directly going to promote and produce economic growth and economic expansion. These are the people that would bring in the wealth that would make jobs possible and improve the quality of life for citizens. And that's always a government priority. So in a sense, what Marshall is doing is establishing or defining a prominent role for government in the operation of free enterprise capitalism. He's establishing a principle of a close relationship between corporate America and government, almost from the very beginning of the nation's history, beginning in the first 2 decades of the 19th century. In that same case, by the way, there are never any dissenting opinions in Marshall's decisions, which I think is interesting. For the most part, they're unanimous. But Justice Joseph Story, writes a concurring opinion in Dartmouth. He wants to make he makes his own argument, which endorses and supports Chief Justice Marshall's argument. And he's talking about what he calls an aggregate corporation. And he said, an aggregate corporation is, in short, an artificial person, existing in contemplation of law and endowed with certain powers and franchises, which, though they must be exercised through the medium of its natural members, are yet considered as subsisting in the corporation itself, as distinctly as if it were a real person. Another division of corporations, he said, is that between public and private. He says, strictly speaking, public corporations are such only as are founded by the government for public purposes, where the whole interests belong to the government. But private corporations are not to be interfered with by government. If the purpose for giving them papers of incorporation is legitimate, then by definition they must be free to carry out the message, their objective or their mission, however they choose to do it, and government does not have a right to interfere with corporations. As an example, Story uses a bank. He said a bank whose stock is owned by private persons is a private corporation, although it is erected by the government and its objects and operations partake of a public nature. The same doctrine may be affirmed, he said, for insurance, canal, bridge, and turnpike companies. In all these cases, the uses may, in a certain sense, be called public, but the corporations are private, as much so indeed as if the franchises were vested in a single person. So what the Marshall Court is doing in 1819 is defining and establishing the principle of corporate independence from government interference. And obviously, that seems to contradict on its surface the idea of government's mission under the preamble to the Constitution to promote the general welfare. The implication of the preamble is, if government is going to fulfill its mission, it must look out for all citizens. It must take an interest in the livelihood of all citizens. And it raises a question: what happens if a corporation, a business, is infringing on the rights of specific groups of citizens? And government immediately, obviously, establishes the principle of its right to regulate So we have here quite a complex legal issue between corporate independence on the one hand and government's responsibility to protect that independence. In other words, protect what Marshall called the individuality of corporations, but at the same time, not at the expense of government's responsibility to manage in a way that will promote the general welfare for all citizens. Because many corporate people, many business people, even today believe that government's number one responsibility is to give business what it wants. And that government ought not to regulate except at a bare minimum. And we know that in our nation today, we continue to have this debate. I think it's very, very significant then, the degree to which Marshall is laying out the ground rules for the promotion of nationalism in this country and the very tenuous role and relationship between the private sector and the public sector. I think it's unbelievable that Marshall took this on this early in the nation's history and how important it is to the nation's future. So to say, as a lot of people do, that the significance of the Washington administration is that it's establishing precedents for future administrations, and the extent to which, as you read the history of the period, it's very clear to Washington and his administration that everything they do establishes a precedent for the future of the nation. What's interesting to note is the Marshall Court is doing the same thing. It's not relying on precedent, it's establishing precedent. It's establishing a body of law which future courts can use and rely on as they seek to interpret the constitutionality of laws being passed in the future under totally different circumstances that existed when the Constitution was first founded. I think this is incredibly, incredibly important stuff. And I have to explain, we're at the bottom of our second hour here. It's 2:28. So I think we'll just forego a break today if that's okay. But obviously, feel free to get up and leave or whatever you feel you have to do. But since I went this long, I might as well just continue and not do our break today. It seems rather foolish to pause for a break at this point with only 30 minutes to go in our program. But anyway, the point that I wanted to emphasize, and the reason I raise these issues at all here in today's program, is because of the political realities today of these issues surrounding the idea of corporate personhood. And realizing that these principles, these precedents, were established in the court, in the court of John Marshall in the early 19th century. And if you're looking at the emergence of the idea of nationalism, and you're talking about the proper role of government in relationship to economic development, you have to include, it seems to me, these considerations of corporate realities. What incorporation means, why it was created. In other words, by offering businesses the right to incorporate, you are encouraging businesses to go into business and take risks. And you're helping them as a government. You're helping them by minimizing their risks. And all of that becomes a factor in promoting economic development of the nation. I think our textbooks are making a terrible mistake when they omit this from considerations in our history books. I did it for years. It's not until Citizens United and everything that has flowed from that decision since 2010 that I really became myself involved in how terribly important this is in understanding the development of the nation and understanding Marshall's view of what the proper relationship must be between government and the private sector. He obviously saw it as tenuous and dangerous and fragile, and he also saw it as something that needed to be defined and established as judicial precedent. And he did it in these early decisions. And unfortunately, our textbooks, our schools, our organized curriculums never, it seems to me, ever get into this in enough depth to appreciate what's there. And so I found myself this morning covering things that never before did I feel the need to cover. And I think it's really important because it validates to me the significance of history itself and the whole idea that you learn from the past. You don't make the same mistakes in the past. History gives us a lot of information if we'll look for it. A lot of the things that we come up against that we believe are unique aren't unique at all. They were envisioned by the founders and by people like John Marshall centuries ago. I think it just makes me appreciate how incredibly visionary and insightful these people were and how much wisdom they set out to share with us. And I'm becoming more and more convinced as I go along that our problem is not that we don't know about the wisdom. It's the fact that we choose to pick and choose which pieces of wisdom we want to focus on, and we ignore the ones we don't. I think these kinds of decisions, unfortunately, are being made in many cases for political reasons. There's, bits of wisdom all over the place that we consciously make the decision to not even acknowledge because they don't fit our particular political perspective or list of priorities. I think that's particularly important. So I think the two things that, as I kind of bring these issues to a close, and, we've got about 25 minutes left in our program, and there are a couple of other things that I wanted to at least touch upon today, since today would be our last day together for a while. And when we come back together again, the first of next week, the Monday, the elections will be the very next day. So it appears that everything that happens between now and the first of next week is going to be incredibly significant in that it's going to directly relate to the elections this coming Tuesday. Even acknowledging that so many people have early voted, including yours truly. I did that also. But it seems to me as we look at the two issues today, President Trump's determination to abolish birthright citizenship by executive order, which raises serious constitutional questions, and the whole idea of government's role in prioritizing contracts and in supporting the priorities of corporations, recognizing that private corporations, are chartered or incorporated because these corporations promise to accomplish things for the public good that government either can't or won't perform for itself. And so from the very beginning, we're seeing a tenuous relationship between government and business in our free enterprise economy. And it's so interesting that for political reasons, ideological ones, we tend to ignore the realities of that relationship sometimes. We find an awful lot of pro-business people who believe that every move that government makes that affects business is wrong, is a mistake, is illegal. That businesses should be free to do whatever they want. In other words, they're denying government's right to regulate the private sector at all. And on the other hand, you get those who believe that government's responsibility to promote the general welfare means that it must be given more latitude rather than less to regulate the behavior of corporations, since corporations are so instrumental in the nation's life and the nation's day-to-day development, because so many people work for corporations, how people are treated, whether their rights are being protected or abused. All of these are government issues, are issues that government needs to be involved in, needs to know about, and needs to be free to interfere in if there's a problem. So I think in both cases today, we've been dealing with issues directly related to the Constitution and also related to the issues of political priorities in the Constitution. I think it's unbelievable when I think about it, how pertinent the Constitution is to everything that happens after. Our politics still being fought over the Constitution. One would think that after all of this time, there would be a general understanding and appreciation of what the Constitution permitted and what it didn't permit, and that issues of constitutionality would cease to be contentious issues. But what we see is that history tells us, the development of the nation tells us, that exactly the opposite of that is true. That as the nation develops, the Constitution seemingly becomes more and more prominent, more and more significant in the political decisions that are being made under it. With that, then, with not too much time left, I'm almost reluctant to get into this without too much time left. Maybe I shouldn't. Maybe I should hold that one. But there's one particular piece that I found really worthwhile this morning, and it's the latest column by David Brooks in the New York Times. And let me tell you why. If you remember, we dealt with Brooks the other day in one of his comments, and I took some issues with some of the things Brooks was saying, and I know many of you do too, because Brooks can be irritating, there's no question, but he's so darn insightful, I think. What he's talking about today, of course, is the violence that we've experienced over the last couple of weeks. But from the title of his article, you'd never know that that's what he was talking about. He entitles this article "The New Cold War." And so naturally, the assumption is, oh, he's dealing with something in foreign policy, when in fact he's talking about domestic policy. And more specifically, he's talking about the people responsible for these particular crimes of violence and near violence, namely the persons arrested. In Pittsburgh, Robert Bowers, and in Florida, I can't remember his first name, Sayok, who mailed the pipe bombs, allegedly mailed the pipe bombs. I guess he pretty well established that he did. What David Brooks is talking about is that when we have these massacres, like we had in Pittsburgh, they all have somewhat the same features. They all have, unfortunately, lots of people who die. There are always survivors who are holding on to each other in mourning. But the focus of his piece is there's always one more thing: a lonely man who's responsible for it. And what Brooks is talking about are the tendencies in our society to become antisocial. Not just asocial, but antisocial. To withdraw. To not be involved in the communities in which you live. To the people who sever social relationships almost entirely. In talking about Robert Bowers of Pittsburgh, for example, Brooks makes the point that what we've learned about him in our reporting is that in high school, nobody remembered him. He was, for the most part, friendless. There weren't people that went to high school with him that even remember him. He was like a ghost. And as he grew into adulthood, he became more of a ghost all the time. As Brooks said, apparently he spent his evenings sitting in his car, smoking, listening to the radio, and, as one person who knows him said, living in his own little world, unquote. And when that happens, Brooks says, people become drawn to extremism, to extreme ideologies, and they become vulnerable to taking actions in a cause that they've convinced themselves is righteous. He said these mass killings are about many different things: guns, demagogy, etc. But they're also about social isolation and the spreading derangement of the American mind. And he points out that millions of people in today's society find themselves alone. Several years ago, in the 90s, there was a sociologist at Harvard named Putnam, Robert Putnam, I believe his first name was Robert, who wrote first an article and then a book called Bowling Alone. And what Putnam was talking about was the emerging tendency in America for people to become more and more isolated, more and more individualistic. People who wanted to become less and less dependent on other people. They became loners. They sought to become loners. And they began to spend their lives consistent with the priorities of being alone. I can remember when this came out in the early 90s. I used to use it in class. I used to use that article, Bowling Alone, in class. Because one of the things that Putnam pointed out was in his research, the title Bowling Alone was based on the idea that late in the 20th century, bowling leagues, bowling teams were extremely prominent. Everybody you talked to seemed to have a bowling night, and they belonged to a team. And at least one night a week, not just men, women as well, and couples, would have their bowling night, their night out, as it were. Putnam points out that his research in the late 20th century was indicating that more and more people were not doing that anymore. Fewer and fewer people were joining bowling teams and leagues. Bowling alleys were having trouble economically because they were losing so much of their business, because the nature of the country itself, the nature of the culture was changing. Fewer and fewer people were church members. Fewer and fewer people were actively church members. Fewer and fewer people were involved in community affairs and community businesses. Membership in community organizations was declining. I saw this myself here in West Virginia, having been a member of the Rotary for so many years. I was president a couple of times. And our membership declined precipitously. And what we were finding was that younger people in the world of business were less and less inclined to become involved in community activities and community groups. They weren't available to serve on boards. Things like the United Way and the Salvation Army and all the rest of it were finding it more and more difficult to find members, volunteers. We were finding it in Rotary. Fewer and fewer people were becoming Rotarians. Nationally, Rotary membership was flat. It stopped growing, and in some places actually began to decline. So you could see so much evidence of what Robert Putnam was talking about in his Bowling Alone. And people tended to become more and more isolated, more and more alone. It's what they wanted. One of the examples that I used to use all the time, when I was growing up, people on a summer evening, people used to sit on their front porches. And neighbors would visit and communicate and talk and play cards with each other and socialize, interact regularly. But in the last quarter century, that's all changed. You don't see, because of the dangers of abuse and things, you don't see parents allowing the kids to go out and play anymore. Parents more and more have taken control of their children's playtime. And some of the experts, psychologists and sociologists, are beginning to question whether in fact children are being deprived of something that's very necessary as they grow up. And that is the opportunity to be children and to interact with other children. School buses bring them to class now. Kids used to walk to school together. And people stopped visiting in their communities on front porches. More and more people began to put privacy fences around the backyard. And they shifted from the front porch to the back patio. And they cooked out and socialized alone. And they built fences to establish borders, if you will, what President Trump's calling walls, to keep others out. I used to lecture in class all the time about the number of people on a Friday night at the end of the work week who'd stop at a 7-Eleven or another convenience store, get a 12-pack of beer for the weekend, go home to their home or their apartment or whatever, lock the door and bolt it and chain it, close the windows, draw the blinds, turn on the TV, drink beer, and basically say, for the next 2 days, I don't have to interact with anybody. I don't have to answer the phone. I don't have to socialize. I don't have to do anything. The fact of the matter is, the nation has moved increasingly in this particular direction. And that's what David Brooks is talking about in this article. And I think it's really significant because it's creating loners. And even though the internet gives us the opportunity to interact and communicate with each other on social media, it actually makes us more and more loners. We live in our own pretend world on the internet. Some of the video games we play, young people play, are about imaginary worlds. People creating imaginary cities. And it's making all of these people vulnerable to the kinds of information and misinformation that's being made available to them technologically because of the internet. And these people are not socially and psychologically grounded well enough to deal with much of the information that's coming to them. And so consequently, we're having these loners who end up living in their own little world. Brooks cites a book by Johann Hari, H-A-R-I, entitled Lost Connections. And Hari makes the point that the mental health issues that we're seeing more and more of today are as much about problems in life as about neurochemistry, what's wrong with their brains. Many people are subject to protracted loneliness, loss of meaningful work, feeling pressure and stress in the absence of community. And this is a quote from Hari. Protracted loneliness causes you to shut down socially and to be more suspicious of any social contact. You become hypervigilant. You start to become more likely to take offense when none was intended, to be afraid of strangers. You start to be afraid of the very thing that you need most. Unquote. And Brooks says, I keep coming back to this as these mass tragedies continue to happen. Brooks says this network of relationships and connection and trust is failing. And the results, unfortunately, are bloody. Brooks says it's time we began to see this for what it is. It's a war. Most of us are part of the problem rather than part of the solution. And that's what his article is about. Brooks says that too many of us have fallen into the trap of radical individualism, which is what de Tocqueville predicted. It causes people to be secluded, cut off from other people. It drives people to become workaholics who have less and less time for community activities and community involvement. The result is it's making us more and more unstable, psychologically and emotionally unstable. And it's very dangerous. And as Brooks said, not only are we part of the problem, but we're also part of the solution. And what we've got to do is look for and begin to find ways to reverse this and overcome it. All of us. We have a vested interest in doing it because there are too many Robert Bowers that are falling through the cracks and going unnoticed. How many times, and I can relate to this, as you think back to these various mass shootings and things, how many times does the media expose us to neighbors or schoolmates or people that said, I knew him, I never knew he was like that? In this particular case in Pittsburgh, for example, the woman that lived in the adjoining apartment to Bowers said, my God, he's a monster. And to think I lived on the other side of the wall from him for 2 years and didn't know it. I didn't know that there was a ticking time bomb on the other side of the wall in my apartment. So as Brooks said, we've got to figure, first of all, we've got to accept the reality that this is a serious problem. And we got to begin to do something about it. It's kind of interesting because in the same paper this morning, the New York Times, Frank Bruni writes an article on the internet. And what he's doing is comparing and contrasting the promise of the internet versus the reality of the internet. The promise of the internet was it was going to make communication more viable. It was going to bring more of us together. It was going to allow us to chat across the nation, across the world. It was going to bring the world together, make it smaller, cause people to become much more aware of, sympathetic to their neighbors and other people. And in fact, it's had exactly the opposite effect. It's becoming an obsession. My wife tells me that I am very close to being a victim of that obsession, because I carve out huge portions of the day that I spend on the internet, that I spend writing and reading and analyzing and all. And part of the reason, of course, for that is preparing for this program. And I value it, all of it, so much. But the fact is, it kind of turns me into a loner. It, over time, makes me feel comfortable only when I'm in my study in front of the computer screen by myself. And I'm spending hours doing that. And it's not healthy. And I know it. And I found, since I've retired, I found that that's a feature of retirement as well. Because when I was working, I was out in the community every day. I was socializing all the time. And once you retire, that's gone. And you find yourself more and more alone. And that's dangerous. And it can be serious. So I think that Brooks has hit upon an important issue here. And I felt that it was worth 20, 25 minutes of our time to at least discuss or approach this particular issue, because I believed it was that important. And I guess with that, we're going to have to sign off. We're getting right. I think we have one more minute left before we get to the top of the hour. I want to thank you also very, very much for your continued support of this program and of Bob Kincaid, Agnes, and the folks at Head On as well. I think the age we find ourselves in and the issues that we find ourselves confronted with make programs, make networks like the Head On Radio Network so incredibly more important than we ever thought that they would be or could be. And it's only because of the support of Bob's listeners that this network has been able to stay together and stay on the air for as long as it has. It's the product of a noble effort by Bob and Agnes and those folks. But it's also a noble effort on the part of those who support the network and support these programs. They are critical. And I can't tell you how much I appreciate, and I know I'm speaking for Bob as well, the continued support. So I want to thank you for it. I want to thank you for the opportunity to be with you for another week, minus one day, of course. I hope that you have a wonderful weekend. I hope that if you got something planned for Halloween, I hope it goes well. And with all things, if everything breaks right, we'll be back together again the first of next week here in the Virtual Center. For Bob and Agnes, this is Bill Obrien. Thank you so very, very much. Have a great week. Thank you.